Good morning. Yes, I welcome all of you to this webinar on the topic Forming a Company for Startups, a complete legal guide to set up a company. This webinar is being hosted by Industry and Innovation Group of St. Joseph Engineering College in association with MHRD Institution Innovation Council, and I, Yatish Kumar, would be moderating this very informative session. I'm happy that so many of you have joined to listen to Professor C. Lionel Aranha, who is a pioneer in this field of entrepreneurship and its legal aspects. I would like to take this opportunity to welcome Professor Lionel. Welcome, you, sir. Professor C. Lionel Aranha is in consulting practice in the finance and legal area for the last 30 years. He has 28 years of teaching experience, of which 23 years are in an adjunct faculty at IIM Calicut. He is also faculty at IIM Indore and IIM Visakhapatnam. He has worked across various sectors including education, construction, infotech, shipbuilding, dockyard, and power. Professor C. Lionel Aranha has a law degree from Bangalore University and is an insolvency resolution professional. He is a life member and panelist of Indian Council of Arbitration of Federation of Indian Chambers of Commerce and Industry, FICCI, New Delhi. Currently, he heads the Native Startup Committee of Canada Chamber of Commerce and Industry, Bangalore. Professor C. Lionel Aranha is also a governing council and governing board member of St. Joseph. Sir, it's a pleasure to have you as a resource person for this session. A warm welcome to you. Without any further ado, I request Professor Lionel to kindly take over.
Thank you very much for that warm welcome, Yatish. I am very glad to be here on a very rainy day, actually. A very good morning to all of you. I will start from the very beginning. See, every business starts with an idea. And it is very important for all entrepreneurs, future entrepreneurs, might be entrepreneurs, to take care of that idea. Now, if it is a patent, you would have registered it, and it would be registered in the name of the person who has done the innovation or invention. If it is a software program and you have taken out a copyright, it is better to register it. If it is a design that you have done under the Design Act, you can register the design in your name. If it is a trademark, trade dress, or even a trade color, you can have it registered. But the most important element of a business is a trade secret. And the trade secret has no law to protect it. That is why I always tell my students that if you are interested in starting a business and you have an idea, first protect that idea. The number of people who should know that idea should be reduced. Like, for example, I'll tell you a very simple example I can give you. Let's say that one of you decides to start a business. Don't divulge that idea to anybody, including your professors, including your peers, including your neighbors, your friends, well-wishers, guides, philosophers, relatives, anybody. You simply say that you want to start a business. What is it about that you say is a secret? And I remember that old proverb in English, he who has a secret to hide should hide the fact that he has a secret to hide. So don't divulge your secret. Next, when you want to start a business, don't start big. I have so many students who come to me and tell me, Sir, I have a idea. I want to start a business and I want to float a company. It can't come in the same sentence. I want to start a business. I want to float a company. First and foremost, we need to know whether this business is workable. If the idea is yours and yours alone, then you start on a very small scale as a sole proprietor. Sole proprietor means, as the word suggests, soul. You are the soul and whole of the business. The business is yours. You are in the business. There is no separation of the business from you. You and the business are one. Minimum fuss, not many legal requirements. You just start the business on your own. If you're taking up an office or you're taking up a shop and you are doing some trading, you may have to get a trade license from the municipal corporation. Otherwise, you can start off on a very small scale. You, your funds, your business, you're testing the waters. If there are two or more people who have joined together and developed the idea, then there is no way out. You will have to start off on a very small scale as a partnership. I will speak about a partnership a little later, but I'm just driving home the point that you don't have to jump immediately and start a company. If the business flourishes, many times it doesn't. In my experience, out of 100 startups, entrepreneurs, approximately 5 succeed. In some times, it is less than 5. In times like this, when we have a pandemic, nothing is happening, it is very difficult to survive. So take it from me, thumb rule, out of 100, 5 will survive, 1 or 2 will make it great. And you could be that 1 or 2 who makes it great. You could be the one who makes it into that 5 category. There is some moderate success among 10 out of 100. You could be there. Now, as you start growing, the problem is vitamin M starts drying up. What is vitamin M? It is money, funds. If you are a sole proprietor, you will suffer because it is your money and yours alone. Maybe you have taken some loans from your family. Beyond that, you cannot go. You cannot approach a venture capitalist or an angel investor and tell him that I am a sole proprietor. When you invest in my business, first and foremost, he will tell you, boss, you have to change the structure of your business organization. Perhaps he will ask you to go in for a partnership, ordinary partnership under the Partnership Act, or he may probe and find out whether there is scope for your business to increase so that you can have start a small company, a private limited company. Or he may say that maybe we can think about a limited liability partnership. Because he's going to invest in your equity, that means your shares, and he's going to invest in your debt, that means in your loans. If you're a partnership, again the same problem arises. Your funds are limited, but better than the sole proprietor. 4 of you, you have your family, and therefore from the family, you may be able to borrow money. But when it comes to angel investors, when it comes to venture capitalists, when it comes to somebody who wants to give money for a startup, invest in a startup, he will tell you, boss, I can't come in a partnership. There are so many problems with the partnership. So therefore, under those circumstances, I want you to start off as a private limited company. And in that private limited company, I will take shares. I will take debt. So at that time, you will have to think about starting a company. Therefore, my introduction is, please don't jump and start a company. Sometimes this company can be a noose around your neck because you can start a company. Legally, law is the one which gives it a recognition, and only law can then put it to an end. Which means to say, if you want to close a company, there are formalities. So just like you have formalities to be observed to start a company, You have got formalities to be observed to wind up a company. Therefore, under those circumstances, first and foremost, remember your idea, test the waters. If you are an individual, go for a sole proprietorship. If it picks up, then we'll see. If you all are 2 or 3 together, then you start off as a partnership. If it picks up, then we will see. When I say then we will see, we will think about converting your business into a private limited company. I hope this is clear to you. Now, some issues that usually come up when we are discussing about business and when we talk about the choice of business organization, there are some questions which I normally ask an entrepreneur. I asked him first question I asked him, what is your ability to raise capital? Usually, people are hesitant. They will say, no, I will take a loan, I will go here, I will go there. I am looking at a quantum. How much of money does your business require? And this you should have at the back of your mind. If you say, I want to raise 1 lakh, 2 lakhs, 3 lakhs, then I will ask you, why are you starting a company? If you say, I require about 1 crore of rupees, then I will say, yes, perhaps company form of business is good for you. My second question to any entrepreneur is this. In what manner do you want to be shared between you and the people who are going to give you funds? To what extent? This question has a bearing because I'll tell you what happens in the world, business world. First and foremost, you started the business. I told you that you have to register all those ideas which can be registered under your name. When you start a company, the risk. Shall I transfer the patent in the name of the company which is now going to be owned by strangers? What will happen to this idea of mine when I have transferred it to the company? Because any intellectual property has a right in it and is transferable. Just like land, land has got a right. Even in intellectual property also you have a right, and that right can be transferred. So are you going to sell it to the company? First question. Second, the business may not flourish. What is the risk? Who bears the risk? If you have borrowed money and if you have given a collateral, what will happen to that collateral? I am now dealing with a case where there is an individual. He started a business in a company's name. The company wanted a loan. He went to the bank. Bank gave a loan in the name of the company, but told him that they want a collateral. Because the company was not doing well at that particular moment in time and that it did not have any assets, he gave his asset because he said that I am one of the directors of this company. I was the one who started it. The patent is mine. Therefore, everything is mine. The baby is mine. Therefore, I will give my property as collateral. Now, the business is not doing well. The times are bad. The banks have now sent a notice to attach his property. What about the other people who are there? The other people have no liability. The other people are happy. They are saying whatever it is, let the assets of the company take care of it. Assets of the company is now on table, 2 chairs. They're not even in their own premises. They're in rented premises. But what about this particular person who has given his collateral to the bank? These are some things which you have to think in your mind when you start a business, and particularly about what sort of business organization that you should go. The third point I always ask is, what control do you want to exercise on your business? I've come across many situations where somebody comes and says, brains are yours, money is mine. All right, brains are yours, money is his. Now, how much of a control on the business does he want for the money that he is going to invest in your business? This is the question that I ask. If it is a partnership, they will say he wants 60% of the profits. He's giving 40% of the profits to me. What is the capital that he's bringing? He's bringing in about 50 lakhs of capital. How much are you putting in? And the poor chap says, I don't have any money, so I am not putting anything in. Then I ask him this particular question: what about the value of your intellectual property? Can you not convert it into capital? Can you not say that I have got this particular patent, I'll value it at 10 lakhs or 20 lakhs, and I will transfer it to the company? That 20 lakhs is my capital in the company. Then there is no argument. But at the same time, you lose control over your patent, because now it will be owned by the firm. Also, in the decision making, this person who has supplied the money, how will he interfere? How will he intervene? Many a times I have noticed that the person who brings in the money does not really interfere. As long as he gets his return, whatever you have promised him, he will not interfere, because he does not know your type of business. I know one doctor who has invested in a person who is developing apps. And the doctor tells me, I have no clue what is happening. I don't intervene and I don't do any exercising any control. All that I get is a return, and I'm happy with it. If you get such type of people, then your business will flourish, because they won't ask any questions as long as you are giving them the returns, the promised returns. But everybody is not like the good old doctor. There are some people who will try to exercise control on the business. They may not have a clue on what you're doing, but they will try to find out, or try to get to understand, and try to say that this is our money, so we should also exert some control. Secondly, he will bring one or two of his advisors. Advisors are paid consultants. They are bothered about what falls on their plate. They'll give you all sorts of advice. Then he'll bring his children, his son, daughter, or somebody will start interviewing. These are all problems that I'm telling you. That is why the most important part is, to what extent am I going to control this? Fourth point I ask people: have you thought about the regulatory framework? For a sole proprietor, there is no regulatory framework. For a partnership act, under the Partnership Act of 1932, all that you require is a partnership deed, register it with the Register of Firms, and you are good to start business. But if you're going to start a company, you actually are approaching a mountain of regulatory frameworks. Why, I will tell you later, because when it comes to a company, you have to understand a few concepts. If you are going in for a limited liability partnership, it is the same, because both a company and a limited liability partnership comes under the registrar of companies. And therefore, under those circumstances, anything to do with the government, there are regulations to be followed, and strict regulations to be followed. There are fines that will be levied. In the worst case scenario, you may be even counting the bars of a cell in the jail. The fifth point that I would like to make you understand is, to what extent, see, in any business, there is always an unseen partner, and that unseen partner happens to be the government. I remember one of my clients, he is no more, but he used to sign, his signature was so and so. He will scribble his signature, and at the end, he will write GIMP. And I used to ask him sometime, what is this that you're signing? You're signing, some scribble, and then very clearly you can make out the words GIMP. What is this GIMP? And he told me, GIMP stands for Government is my partner. Of course, it can also stand for God is my partner. But in our case, this gentleman, a very jovial gentleman, used to say, I am earning for the government as well. So there is a tax burden for the entity that you have established. If you look at the sole proprietor, the business income and your income is treated as one and the same and you're taxed. If you're a partnership, for the purpose of tax, partnership is considered as a distinct entity. Partnership pays taxes. On the profits that you get from the partnership firm after having paid the taxes, you don't have to pay tax on it. Moreover, if you're working in the partnership, certain salary based on certain limits that are there in the Income Tax Act, you will get. In the sense, it will be allowed as an expenditure for the firm. Therefore, your salary, your tax burden comes down. When it comes to a company, it is a distinct legal entity. The company earns profits. On the profits, it pays tax. And then it declares dividends. In some years, the government will say that there is dividend tax to be paid. The company pays the dividend tax and gives the money to you. You don't have to pay tax on the dividends. But now the government says, no, it is not that way. The dividend that you receive will be added to your income and you will have to pay tax. There is no dividend tax to be paid by the corporation. You will have to pay. Corporation means the company. Company does not pay any tax. Company pays tax only on the profits. On the dividends, you pay tax. So all these points you should note down somewhere because these will determine what sort of a business organization you want to get into at the initial stage of your business life. So first ask this question, how much of capital do I want? In what manner am I going to share the risk with not only myself, but the people who have given me the money? How much of control am I willing to exercise in this business, or how much of control am I willing to give up in this particular business? What about the regulatory frameworks? And finally, what is the tax burden for the entity and the owners? Now, these are some points which you should take into consideration when you're having a conversation with anybody who is helping you start off a business. Because as soon as you go to a consultant, the consultant is not bothered. He will tell you, this is what we'll do, and we'll go ahead. Because he's not running the business. He has no hesitation in telling you, let's do this and let's do that and all those things. But you, as an owner of the business, should come with an idea and then tell the consultant that I want this to be done. Many times people make the mistake. They go to the consultant and ask him what we should do. And he does it according to his whims and fancies because he's not the one who's investing in the business. He's not the one who's running the business. He's taking a fee from it. He doesn't feel the pinch when the business goes down because the fees have already come. Therefore, under those circumstances, what I normally tell people is, I tell people, say, these are the points, go home, think and come. Or if you don't understand, I will explain. And then you tell me which form of business organization do you want. Then only I will proceed. I hope this is clear. So let me go a little further. Now, I want to not jump straight into company. I have kept some time to discuss about a partnership. Because many a time people come to me and tell me, we feel that we need to test the waters first and we don't want to start a company right away. So can we go in for an ordinary partnership? A partnership under the Partnership Act of 1932. I said, all right, fine, we can. So you have to understand the characteristics of a partnership before you plunge into partnership. Partnership is the relationship between persons who have agreed to carry on a business and who have also agreed to share the profits of the business being carried on by all or any one of them acting for all. Some of you will get a little confused. Let me break it down and explain to you what is partnership. And let me tell you some advantages, some disadvantages. And you will then understand a little better about a partnership. At the outset, let me tell you, no partnership lasts forever. Because One, partners may want to retire. Two, partners die. And when a partner dies, the business partnership actually is totally dissolved. In my experience, partnership is like a marriage. I have seen, if the couples get along well, they will celebrate 25 years. And if they last, then they will celebrate 50 years of togetherness. In partnership also, there are some partnerships which have celebrated 25 years. Same partners, actually not family members, classmates who started off a business together, and they have lasted all this while, 25 years of business. And they're doing well, flourishing. They have not changed their business structure. They are still continuing as partners. But unfortunately, these cases are few. Partnerships don't last. And many times I am called for mediation, for conciliation, for negotiation, even arbitration, where partnerships are concerned, and dissolution of the partnership has become a very painful process because of the assets and the liabilities that it possesses. This is because a partnership is not a distinct legal entity. It is not removed from the partners. The partners and the firm are one and the same. Now, some points that you should remember when you are discussing about partnership. Partnership is a result of an agreement. So when you go to a chartered accountant and you say that you want to start a partnership, what he will do is he will reach out for his laptop or his computer. He will make one dummy agreement and give it to you. You will have a look at this and you fill in the details. How many of you as partners? What is the capital that you are bringing in? What is the profit sharing ratio? And some of the clauses are completely as per the partnership agreement. That is, it is common. It is there in every partnership agreement. That is why it is in his computer. All that he has to do is change the names, change the profit sharing ratio, print it on a stamp paper, take your signatures, go to the registrar of firms, register it, and you start your business. No issues, no problems at all. So therefore, it is an agreement. Okay. Second, it is an agreement to do something. What is that? That is to carry on a business. What is business? It is an activity which gives rise to profits. I'm not saying all businesses give rise to profits. There are some businesses which give rise to loss. Loss is called a negative profit. But that activity, whether some people ask me this question, we want to do a business which is only temporary. Can we do a partnership for that? I said yes, because it is a partnership which is going to last for a particular term. Now let's imagine mango season. Two people come together and say, we will enter into a partnership to sell mangoes. Of course, nowadays, since storage facilities are excellent and we have got mangoes throughout the year, if you want, you can actually have mangoes throughout the year. All fruit today is available throughout the year. Earlier, it was not like that because there are some very good storage facilities, particularly if you go to Madhya Pradesh, you will find huge godowns, you would say warehouses, refrigerated warehouses where fruits are stored. I've gone to one and I've seen it. So business is not seasonal now, it can be done throughout the year. But let's say that they come and say, we want only for 3 months, the mango season, we want to enter into partnership. Partnership is going to run into crores of rupees. So therefore, you want something in writing. Yes, you can do it. For a particular adventure, you can do a partnership. Partnership is done for adventures when you do movies. The producer enters into a partnership with the director, with the music director, with the actor, or whatever it is, and he makes a small partnership and he says it's only for the purpose of this movie. We will take out this movie, then we will give it, sell it to the distributors, and we will share our profits and walk away. Fine, no problem. It can be an adventure, it can be a continuous activity, whatever it is business. It is an agreement to carry on a business. The third point you should remember is that this business will give rise to profits. Therefore, you have to agree to share the profits. In fact, in partnership, you have a right to profits, share the profits, and you have a duty to share in the loss. So I'm making this distinction very clear. You have a right to share in the profits, but you have a duty to share in the loss as well. Now, how this profits are going to be apportioned amongst you, that is up to you. So I told you sometimes, my brain, your money. So the person who has the brain will get a lesser share of profit because the money that is coming in is more vitally important. That means you have not negotiated properly. The other day there was a youngster who had come to meet before the coronavirus came, and his uncle was going to give him the money. So uncle told me, he thought it is like, he's going to control the nephew. He said, nephew will get 10% of the profit. I will get 90% of the profit because all the money is mine. Then I looked at the uncle and said, then who's going to work? My nephew is going to work. And then nephew getting 10%. Nephew's idea, why does he want to get into a partnership with you? This is slavery. Under those circumstances, he said, okay, what can we do now? I said, see, it is, if you want your nephew to really be interested in the money that you're investing, give him a larger share. Give him, say, 40%, or give him, say, 35% and give him a salary every month, let him take a salary. Whatever remains, then it will come to you. Because if you don't do this, there will be no interest in the youngster to work. The uncle understood, and therefore, under those circumstances, he said yes. But what happened, unfortunately, the lockdown came in, and I don't know where they are now. The partnership, I'm not very sure. The other day, they called me up and said, we will come to you after the virus has gone away. I don't know when the virus will go away, but they are there somewhere, suspended their business. I'm not very sure. This agreement to share the profits is very important. Now comes the most important part in a partnership, and this is the point which gives a lot of headaches to a lot of people. It is said that the business should be carried on by all or anyone acting for all. If you have read Dumas's, what shall we say, that Three Musketeers, it sounds like that. All for one, one for all. And businesses in partnership is that way. It says that it should be carried on by all or anyone acting for all. That means active participation by everybody in the business is partnership. In law, we call this as the concept of mutual agency. That means one person, one partner can represent the other partners. One partner becomes the agent of the other partners. He's not the agent of the business, he's an agent of the other partners, because the business is not a separate entity. It is firm means. Therefore, when you say that a person, business is to be carried on by all or anyone acting for all, there is an element of mutual agency. Some of you who know a little bit of law will understand that in a contract of agency, there is a principal and an agent. Partnership is an extension of the law of agency. Therefore, you will find that in a partnership, every partner has a dual role. He is an agent of the other partners and is a principal of the other partners. If this particular aspect is missing, it cannot be called a partnership. That is why the real test of partnership is this particular concept of mutual agency. If you are a person who is comfortable in this sort of a scenario, that an act of a partner binds the other partners to that act, then you go ahead with partnership. Otherwise, you think about it. Law makes a distinction. Law says, look, an act of a partner is an act of the other partners, applies to normal activities. If you are a firm which is into trading, then it also extends to any loans which a partner may take from third parties, saying that it is for the partnership firm. Let's say that you are a person who has run a business, and this is in Bandar. You are trading in groceries, you are trading in grains, you are trading in spices. One of your partner is a little errant. He always has a thirst for money. So he meets a third party somewhere in Taj Mahal cafe for coffee, and he says, "Nammadondu business unto it is doing extremely well. We need a little money," and he takes money from that particular person. Now understand that he has taken money for the firm. The third party can sue the partners and get his money back, and the partners cannot say, "We did not know anything about it." This is the problem. If it is not a trading firm, let's say it is a firm of lawyers, then the question doesn't arise where he can take money, because there is no necessity of money for a firm of lawyers. They're not into trading. Also remember, this act of one will bind the other partners to that act does not arise when immovable property is involved. That means a partner cannot sell the immovable property without including all the partners in that sale deed. This is something that you should remember. Now, one of the questions that people keep asking me, just the other day I had one case where they have formed a partnership, but they have not registered it. And somebody told them that if you don't register the partnership, you don't have a partnership. Now, you should understand that if you look at the Partnership Act of 1932, nowhere it is mentioned that partnership has to be registered. But if you read the Act, it will tell you two things. If your partnership firm is not registered, then when you cannot go to the court of law. Let's imagine that you have a partnership. It is present only in a partnership agreement. This partnership agreement has not been registered with the registrar of firms. So yours is effectively an unregistered firm. Now somebody has not paid you the dues. When you go to court against that particular person and you produce your partnership agreement there to show that you are a partnership firm, the bench clerk there will say, idano nanu accept madlikke agudilla because this is not registered. Please go register and come. At that time you can register it and then come back and still fight the case. No problem, no issue. Second, and more importantly, if you have not registered your partnership firm and you are a partner in that partnership firm and you want to enforce that partnership agreement, you cannot, because the partnership is not registered. That is why we always tell people, kindly register it. Also, it is important to note that under income tax laws, a registered partnership firm is taxed at a lower rate. If yours is an unregistered partnership firm, it is treated as an association of persons. In association of persons, the tax rate is higher. So, think about a partnership. Let me tell you a few more things about partnership, and then I will move on to company. Now, I told you right at the very beginning that partnership requires meeting of minds. If you have got like-minded people, you have tested them, the relationship is very strong, then you can go in for a partnership, and this partnership can last for a very long time. Unless, of course, money is required. You can't raise it yourselves, or you cannot approach the bank. Maybe the bank says we want collaterals and you don't have collaterals. Therefore, you look at an angel investor or you look at a venture capitalist and he says, I don't want to come in as a partner into a partnership which I do not know who you all are. So I will want you to convert this into a, what shall we say, joint stock company, a limited liability partnership. But usually they ask for a limited liability company. Then you might have to convert it into a company. Otherwise, please remember that partnership firm can go on for a few years. As I told you, I know of partnerships which are there for 25 years. But usually, I am a little reluctant to go on the limb and say that partnerships really last. They don't. I have seen partnerships started by family members which disintegrated. I have seen partnerships which were running beautifully, fantastic businesses, disintegrated because of misunderstanding between the family members, not the partners as such. Because when you are in college and you are alone and you start a business, it is okay, fine, because you all are our partners and you are good friends. After that, you get married. When you get married, what happens is for every harmonium, you get a tabla, or vice versa. For every tabla, you get a harmonium. Now, this harmonium, if it sings off or is not tuned properly, not attuned properly, it plays false notes, then your business is supposed, I can assure you, I can actually bet my beard that it will not last. The minute partners spouses start taking interest in the business, then please remember that there is every possibility that the business will be lost. Questions will be asked, and and unnecessary interference will be there. Therefore, better to go in for a company at that particular point in time, because then there is no interference, and you simply say that we are only directors, we do not know there are shareholders and all those things. So, I hope I have made myself clear so far. If you have any doubts, I think you can always ask. Let me proceed. My next point for discussion would be a company. What is a company? What are the characteristic features of a company? Why a company? You see, the best part of a company is that it is a separate legal entity. Sole proprietorship is not a separate legal entity. Partnership is not a separate legal entity. It is only a separate legal entity. I wouldn't say entity. It is treated as a separate unit for the purpose of taxes. Otherwise, partners and the business are one and the same. Whereas when you come to the company, it has got an entity. It is an entity. It is what we call as an artificial person created by law. When I say artificial person, let me explain. What's the difference between artificial person and living person? You see, the company has no body to incarcerate. Most importantly, it has no soul to redeem. Whereas we human beings have a body to we have a soul to redeem. In fact, there are some people who will tell you that this particular characteristic feature of a company, that it is a separate legal entity, has actually created a lot of complications in why? Under the guise of this separate legal entity, companies have done a lot of crimes and got away with it because it is a separate legal entity. When I say companies have done it, it's not the company that has done it, people have done it, and they have taken recourse under this particular characteristic feature that it is a separate legal entity. I can give you a lot of examples. Let's take, for example, Johnson and Johnson. It's a company. Its talcum powder is supposed to be containing traces of asbestos. And asbestos, as you know, is carcinogenic. How is asbestos found in talcum powder, you may ask me? You see, if you do some research, you will find that talcum is a mineral and asbestos is also a mineral. Both these veins of minerals are found in the earth, and there are instances when these veins are close to each other. And distinguishing is a little difficult, though, of course, talcum is soft and powdery. Asbestos is powdery, but not soft. So there is every chance that somewhere when you were mining, there was a mix of asbestos into talcum. People used the talcum powder and developed cancer. You know that ovarian cancer, the lady developed, she died, and she was paid millions of dollars in, her estate, legal estate was paid millions of dollars as a fine, as a damages by the company. Did the company go to jail? No. If you and I had done it, we would have gone to jail. I remember the case of Pfizer. Pfizer is a pharmaceutical company. There was a outbreak of meningitis in Nigeria. Pfizer was testing some tablets, some cure for this meningitis. It had not done field trials. It is supposed to have lied to the government that it had done field trials, but actually it was looking at candidates for field trials. Meningitis was widespread. It was killing children. The military leadership of Nigeria want to get out of this mess. Therefore, when Pfizer approached and said that we have a tablet which could stop this, they gave permission for Pfizer to give or try this experiment in Nigeria. 200 children were selected. 100 were given one type of tablets, the other 100 were given another type of tablets. If I'm not mistaken, about 21 children died, and most of the children developed physical deformities. If you and I had done it, I think by now we would have been history, in the sense we would have been tried for murder, and we would have been maybe rarest of rare case, we might have been hanged. But nothing happened. Pfizer was fined $25 million. Not even its executives were also not punished. And look up in history, and you will find that this separate legal entity has been misused by many companies to get away from what they have done. That is why there is a big question mark when people say that a company is a separate legal entity. But for us, let's not go to that extreme. Let's say, from our point of view, is it a good thing? Yes, it is a good thing, because unlike a partnership where one of the partners in writing can ask the partnership to be dissolved, in the case of a company, that dissolution does not take. If a shareholder, we call him, is not happy with the way things are being run in the company, he sells his shares and moves on. He does not ask for a dissolution. Whereas in partnership, what happens? One of the partner has a right, if he feels that things are not going well, or he is being ignored, or he has got trouble with the other partners, he can just notice to the other partners and ask for a dissolution. And at that particular point in time, his request has to be honored, the business will be dissolved. Will the business survive the dissolution? That is a big question mark. Whereas in this case, it is not possible. If I don't like the company, I sell the shares of the company and move on. That is why there is an active share market when it comes to public limited companies and publicly held shares. Private companies do not have an active stock market, but if you want to sell the shares, you have to sell it back to the company. The company fixes a formula and on which it will buy your shares. But you cannot ask for dissolution. Second point you should remember, as far as a company is concerned, it has got limited liability. I did not raise this point in partnership because I knew that I was going to raise it here and I want to connect it. What is limited liability? Take for example, we'll go back to partnership. In a partnership, let's say you have borrowed money from a bank. The partnership cannot pay back this loan. The bank will come after all the partners. To what extent? To the extent of a private property as well. So one of the biggest sword hanging over a partnership is that it has got unlimited liability. Unlimited liability to the extent where partners have to give their personal effects as well. What may be left is maybe your trousers and shirt to cover your shin. Otherwise, if that is also valuable, creditors will take that also. It happened in Rajasthan. One of the prince, he had a gown in which there were semi-precious stones. And when the creditors came, he said, I do mere paas kuch nahi. I've got this gown with me. So one of the creditors actually removed his shirt and pant and gave it to the prince and took the gown and went. And he said that this is valuable, I can make some money out of this. You take this, wear my patloons, I will take your gown and go. So in partnership, there is this unlimited liability. This is like a sword hanging over the head. But when it comes to a company, the liability is limited. Limited to what? Limited to the shares that you have taken in the company. And if you have subscribed and paid the whole amount, then there is no liability at all. Sometimes banks may ask for a guarantee from the directors. At that time, perhaps the liability of one of the shareholders will be more than the other shareholders because he is a director of the company. has happened in many cases where have guaranteed loans, and then the banks can proceed against the guarantors and get the money back. Otherwise, please remember, financial institutions have recourse only to the assets of the company. They don't have recourse to the assets of the shareholders. Whereas in a partnership, the financial institutions have recourse to the assets of the firm, and if that is not sufficient to pay the loans, then they have recourse to the assets of the partners. This is something which you should remember. Third point, a company has perpetual succession. We call it as perpetual succession because a company outlasts its members. I told you, in partnership, if the partner dies, the partnership is dissolved. Whereas in the case of a company, if a shareholder, what happens? His legal heirs become the next shareholders. Today, if you ask me, who are the legal heirs? There's a funny ruling by the Bombay High Court which says that the nominee of a person's demat account become the new shareholders, not the inheritors per se. The case that was fought in the Bombay High Court was a gentleman died. His nephew was the, what shall we say, nominee of his demat account. The nephew was recognized as the inheritor of the shares of the deceased shareholder, not his son and wife, and wife went to court, and this was the ruling which was given by the Bombay High Court. Therefore, understand this, that when it comes to a company, the company lasts forever. As long as you want it to last, it will last. If you want to close it down, then you have to follow procedures. You have to wind it up, and today winding up is done through the NCLT. You have to go through that particular process, a painful process of liquidating the company and then giving the money back to the creditors, and whatever remains goes to the shareholders. The liquidator has to be appointed. The liquidator will then make a payment to what is written in the company law. There is a waterfall which has to be followed. You simply can't distribute money just like that. So first you have to pay the fully secured creditors. Then you have to make provisions for the liquidator's remuneration, for the liquidator's expenses. Then you have to pay the partially secured creditors to the extent of the security. Then you have to go down. It goes down, 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 down. Ultimately, it comes down to the shareholders. Shareholders sometimes don't get anything. It's like you have gone very late to a wedding, and then you go to the catering counter, and that person there, the caterer, is only waiting now to go home or to have his food. So he will make a lot of noise in the vessels and then beat everything up so that even what is there in the spoon also falls down, and then he will pick something and give it. That is the state of shareholders sometimes when liquidation takes place. But understand this. Perpetual succession means law has created it, only law can bring it to an end. Therefore, companies, I know companies which are there from the last 400 years, 500 years, they've celebrated so many centuries. That is because of this particular perpetual succession. The next point that I would like to make as far as a company is concerned is that it has got a common seal. Every company has to create a common seal and keep it with it. It is not a seal that is what you think, it's not a rubber stamp. It is a embossing seal. It is where the mark, the seal mark, actually embosses on the paper. Not to be used for all contracts, it is only to be used for certain contracts. Like, for example, I'll tell you, if the company is buying immovable property and a sale deed has to be done, then the sale deed has to be signed by somebody authorized in the company. It could be the managing director or whoever it is. But when he signs, he also puts this particular common metal embossing. So if you're buying property from a company and you're looking at the papers, you will find this particular seal. It is not got, in some cases you will find ink there, but sometimes it is not ink. Only the embossing you can see that it is. That is a common seal that companies possess. It is one of the characteristics of a company. Now the company's capital is divided into shares. People contribute to a common pool. This common pool is divided into parts. These parts are called shares. One share makes you a member of the company. In private limited companies, that is where we have only about 200 members, the transferability of these shares may be restricted. If you want to transfer the shares, if you're not happy with the company and you want to go out, then you might have to give these shares to the existing shareholders. They might work out a formula and tell you that we can offer so much for the shares and we will take it. But when it is a public limited company, minimum 7 members, maximum any number, where the shares are traded on the stock exchange. And if you are a very shrewd investor, even in this time, you can protect your investments. I know a lot of people who are heavily into trading on stocks and shares. I'm not talking about those who look at the screen, buy, sell, buy now, sell later, and all. Those are all punters. They are all what you call in a casino. They are trying to get some money every day. Not those. I'm talking about a long-term investor. A long-term investor, if he puts money in it and then takes it out when he wants it after many, many years, is known to have made much more than what he would have made if he had left the money in a bank in a fixed deposit. Their shares are freely traded, so you don't have a problem. You don't like the company, you sell it. Sometimes what happens is people buy stocks, then they find that, oh, this is not happening, so let me sell it. Some stocks have a great demand, some stocks don't have a great demand. Today, if you're talking to me and I'm telling you that, look, FMCGs have a good demand now. Banking stocks nobody wants. Auto stocks nobody wants because nobody wants to buy a car now with the prices skyrocketing of the fuel. Banks nobody wants because there is every chance that the NPS will rise. I am told that at least 65% of banks' portfolio of loans is under moratorium because people are not paying. So we are looking at a very dismal scene when things really start again. We may have to look at a lot of NPAs. But I'm telling you, transferability of shares is one of the very interesting feature of a company. Now, when it comes to property, can a company own property? Yes. Whatever funds of the company are used to buy property, it belongs to the company. It does not belong to the shareholders. Shareholders at no point in time can go and say that this belongs to me, that belongs to me, that brick belongs to me, that chair belongs to me. That cannot be. As a separate property, it is owned by the company. Now you may ask me, what happens to the property of a partnership? In a partnership, what happens is the partnership property belongs to the firm, but I told you firm is not distinct from the partners. Therefore, what happens is every partner has a right in it. Shareholders don't have a right in the property. The assets of the company, if it is being dissolved, will be sold. And I told you that there is a waterfall. It has to be paid in that particular format only. Shareholders can't take the money first. Shareholders are somewhere the last people who will get them. Just before them, they will be preference shareholders. Just before them, they will be the debenture holders. That is, one unit of debt is called a debenture. Those will be. They are not the owners of the company. Shareholders are the owners of the company. They will get the money last. So a company is capable of owning property in its own name. It enjoys the property in its own name, and it can dispose it off in its own. But partnership cannot do. Since it is a distinct legal entity, a company can sue and be sued in its own name. You need not sue the directors and all that, but you can sue the company and the company can defend itself because it is an artificial person. When you're suing a partnership, you cannot do that because when you're suing a partnership, you have to sue the partners, and you don't have to sue all the partners. If you find one partner, you can sue him. He cannot cry and say, wait, let you catch all the others. No, because in a partnership, the liability is joint and several. We call it as joint and several liability when it comes to a partnership. When it comes to a company, it is not joint and several. The company is responsible for its debts, therefore it can be sued in its own name. It can sue in its own name. Whereas if the partnership firm is going to sue, and if the managing partner has been given the right to sue, then in the court they will ask for the resolution passed by the other partners. They will ask for a general power of attorney of the other partners, whether they have given a power of attorney to the managing partner to sue. Just the other day, one case was thrown out of the court because the lawyer forgot to attach these documents. He did not give the GPA, he did not give the resolution passed at the meeting of the shareholders. Therefore, the opposite party said that this managing partner has no right to file the case. And therefore, now the case is delayed because after 2 years, the case is thrown out because the judge says this partner has no right to file the case. He does not say that the case is wrong. So now again, they have to go back to the drawing board. Now 2 years are gone and the money has been spent, a lot of money has been spent on the case. So again, you'll have to go back and file the case and again you'll have to file it. So that things happen in partnership, but it doesn't happen in the case of a company. Now, many times people ask me, who will manage this company? We have created it. It is a separate legal entity. It has got a separate property. It can sue in its own name. But who is going to manage this company? The management of the company is through a board of directors. Today, things have changed. Earlier, it was, when I say board of directors, it would be friends, philosophers, guides of these people who could subscribe to some minimum subscription and become directors. Today, it is not so. Today, in every board, there has to be at least 1/3 independent directors who are in no way connected to the shareholders, no way connected to the directors, no way connected to the company. These are independent shareholders. This came about because of the scandal which took place in America. Not exactly the scandal came later, but in America, and in UK, there was this doubt among people that this board of directors are the shareholders. Actually, the shareholders said that this is not working out because there is no independence on the board. Therefore, when Lord Cadbury was selected to make a study, and he came up with recommendations that on the board of a public company, there must be independent directors who will monitor the way the company is functioning. As this discussion was going on in America, a few companies went down under. Prominent among them was a company called Enron. Those of you who are trusted, there is a book by Bethany McLean, which is called The Smartest Guys in the Room. It's about Enron. Based on that, they had made a documentary which actually ran as a commercial film. I mean, it was very well made. The collapse of Enron. And why I'm telling you this collapse of Enron is because this collapse of Enron triggered the American judicial system to bring about an act of having independent directors on the board. The act was called as the Sarbanes-Oxley Act. Was adopted by India, but at that time it was not there in the Companies Act. We were still following the Companies Act of 1956. But in 2013, when we got a new Companies Act, it was incorporated in it. The Sarbanes-Oxley Act of independent directors on the board was adopted by our act, and it was put into the Companies Act. Today we have got independent directors on the board. Of course, it was also triggered because we had our own Enron in India, and that was that a company called Satyam, if you remember. Some of us do remember it. Went down the drain. It was then taken over by Tech Mahindra. Now it's called Tech Mahindra, sorry. It was taken over by them. Satyam was a huge scandal some years back. You can look it up. Now these directors are elected by the shareholders. It is like a democracy. Company talks to the shareholders through meetings, and one of the very important meeting of a company is the annual general meeting. And this annual general meeting, you have to select the directors for the board. Election takes place. Sometimes no election takes place because there are no candidates. Everything is done on consensus basis. And you have to have independent directors which are nominated by the board. And today, the Company Affairs Ministry has got courses which are presented to people to become independent directors. You have to take the course, you have to answer an exam, and if you answer the exam, if you pass the exam, you get a certificate. And you will be then put on a panel, and any company can select you as an independent director for their board. Let me proceed a little further. One thing that you should remember, I keep telling you that company is an artificial person, but it is not a citizen under the Citizenship Act of the Constitution of India. But for the purposes of taxation and for the purposes of management, it has got nationality and it has got residence. That much you should remember, that it has got nationality and it has got residence. Like for example, we say international company, domestic company. And for the purpose of residence, we say that this company is resident in India, so tax rates are such. This company non-resident in India, therefore taxes are such. How do you come to the conclusion what is residency, what is non-residency depends upon the management. Where does the head sit? That is besides the point here, so I will not go deep into it. For a private company, I said maximum number of members are 200, minimum is 2. And for a public limited company, we only say the minimum number, 7. The upper limit maximum is not mentioned. Now, curiously, in 2013, the government came up with a one-person company. Very strange. A one-person company. This was to encourage a sole proprietor to also have a company. We call it as OPC, one-person company. Your capital has to be less than 50 lakhs. Your turnover has to be less than 2 crores. You have to have a nominee, because if anything happens to you, who's the person to fall back on? So you should have a nominee. You should have a board of directors. Minimum is 1. That is, you yourself can become a board director, managing director, everything you can become. And please remember, the provision has been kept in the Act to have at least another maximum you can have is 15 directors for a one-man company. I mean, I'm a little taken aback. One-person company can have up to 15 directors. And once you take out, register a one-person company, for 2 years, you cannot change it into any other character. You cannot change it into a partnership. You cannot change it into a private limited company. But if your turnover goes beyond 2 crores and if your share capital goes above 50 lakhs, immediately it has to be converted into a private limited company. That means you have to one more member, 2 members minimum is required, and then you have to go in for a memorandum of association, articles of association, and such other things. That means you have to comply all the requirements of forming a company. I just wanted to mention that there is a possibility of a one-person company. So sole proprietors need not feel bad that we cannot form a company. A company can be formed. But please remember that your turnover and your capital is very important. Okay, let me proceed now and let me get into the nitty-gritties of starting a company. Now, when you start a company, first and foremost, you should understand a few things. It all starts with promoters. Who are the promoters? Promoters are those people who have an idea and who want to form a business organization. They become what we call as promoters. These are the people who will now bring to birth a company. These are the people who will consult auditors, lawyers, draw up a memorandum of association and articles of association, who will apply on the website of the registrar of companies for a name to be reserved for their company, who will have the memorandum of association and articles of association stamped under the Stamp Act, who will subscribe and sign the memorandum of association and articles of association before they are stamped, who will agree to become the first directors of the company, who will upload these documents online, who will pay the registration fees, the directors, of course, will have a director identification number will be taken out in their name. Who will, after uploading these documents, wait for the certificate of incorporation? These are whom we call as promoters. Promoters are not your auditors and your lawyers. Promoters are the people who are the first shareholders. Promoters are the persons who want to form a company. Therefore, under those circumstances, they are the ones who do all the documentary work. And they are the ones who actually register themselves, help register the company. That is why I said these are the people who bring the company to life. Let me first speak about the filing process. Then I will come back to telling you what is memorandum of association, what is articles of association. By the time I think we will run out of time. Some of you have sent some questions. Some are relevant, some are not very relevant. I will spend about 5 or 10 minutes on those. Five minutes only I can spend on those questions. Now, the procedure is as follows. First, you select a name. In order of preference, up to 6 names you can give. And when you are giving these 6 names, please take care to see that they have some connection with the main objectives of the company. If they are not in sync with the main objects of the company, there is every chance that this name may not be approved by the registrar of companies. Your name will not be approved if it resembles or is similar to an already registered company. Your name will not be registered if it is violative of the provisions of the Emblems and Names Prevention of Improper Use Act, which came into force in 1950. All this you can do on the portal of the Registrar of Companies. You have to file a E-Form 1. You have to pay 500 rupees. And you have to ascertain the availability of the name. As soon as an availability of the name is there, the person who is signing it will have to have a digital signature. This form is to be uploaded with the application fee. If out of the 6 names, no name is available, you have to make a presentation. So the first and the foremost thing that you have to do is to reserve a name for your company. Now, this name you are going to utilize it when you are drafting your memorandum of association and articles of association. This memorandum and articles of association will be drafted by some paid consultant that you have hired for the occasion. Within 60 days approval of the name, you will apply for the registration of a company and you will fill in the forms. That is, you have to fill in a Form 1, Form 18 and Form 32. Normally, the memorandum and articles of association are drafted by your solicitors or your auditors, who will arrange for the stamping of this memorandum and articles of association with the appropriate stamp duty. These articles of association and memorandum of association has to be signed by at least 2 subscribers, who will sign, who will give their father's name or husband's name, who will give their occupation, who will give their address, and who will also state how many shares they are subscribing to. And of course, they must be a witness. Normally, one person is sufficient to having witnessed this particular signature. Memorandum and articles have to be stamped, but you ensure that the signing is done before stamping this. Then you log on to the portal and you upload these forms. They're all in e-form, so you have to just fill it up and then just upload it. And in about, say, 8 to 10 days time, you may have a company ready. A corporate identification number will be generated and you will get a certificate of incorporation from the RFC. With this certificate of incorporation, your company has come to birth. The date on which your company has been would be the date you find on the certificate of incorporation. It's a very simple process, and there are chances that your company could be registered even in 2 days' time. I know of a person who got his company registered in 2.5 days. So it's not a big process now. Only thing is that you have to get the articles, memorandum ready, the name has to be selected, the name has to be reserved, and then within 60 days you have to file the other forms that are required. And among these forms, you have to also, the form number 1 talks about declaration of compliance. Form number 18 talks about where your registered office is going to be situated. Form number 32 is going to talk about the managing director, and if you have a manager or a company secretary, their details have to be uploaded. This is simple. So it is not very difficult to start a company. Company starting is absolutely easy. Winding up the company is the painful process. The liquidation of the company is a very painful process. Now, there are 2 very valuable documents which a company is incorporated on. And is the memorandum of association. So let me tell you what this memorandum of association contains. If you look at the memorandum of association, you can go to the website of, you can just key in the data in Google, you can say memorandum of association of a particular company, and you have it, because everything today is digitalized and it is available, because this memorandum of association, once they are uploaded on the ROC's website, they become public documents. In fact, to tell you this is something which is very legal and which is very important, is every person dealing with the company is supposed to have read the memorandum of association. We call this as a doctrine of constructive notice. That means once these documents are uploaded, they are public documents. Whosoever is entering into an agreement with the company is supposed to have read the memorandum of association, because this memorandum of association speaks to the public, because a company cannot speak. A company speaks through the memorandum of association, and therefore what does the memorandum of association consist of? It consists of the fundamental conditions on which this company has been formed. It consists of how it is going to regulate its external affairs with outsiders. And most importantly, Any person who's dealing with know the permitted range of its enterprise. Therefore, a company, if you look at the memorandum of association, you will find first a name clause. That name that you have registered, you put over here. It will have a registered office clause. That means where is your registered office going to be situated? Registered office means the office at which notices can be served on the company and the company operates its office from that particular place. It is fashionable to have a registered office, then you have a corporate office, and then your factory somewhere. Fine, no problem. But it's that registered office that is very important for the purposes of issuing notices and the company issuing notice from that particular address. Third, you will find when you look at the memorandum of association, you will find an objects clause, a very chunky paragraph of objects. That means what is the permit of enterprise of this particular company. And please remember, in the objects clause, whatever you have put, that stands. You can do only those activities. You cannot go beyond those activities. If a company goes or does something beyond what is stated in the object clause of the memorandum of association, we say that the company has gone beyond its powers. It becomes an act which is ultra virus. Ultra virus means beyond its powers. And this act does not confer any benefit or privilege on anybody. That is, people ask me why this is so strict, why this object clause is very strict. Because the company is going to attract investments from outsiders. It's going to it's going to attract investments from shareholders, attract investment from creditors. And therefore, they should know what is the permitted range of activity so that money is not squandered away, money is not wasted. Usually, you will find in the object clause two headings. You'll find the main objects and you'll find at the bottom ancillary objects or other objects. This is first you will find main objects and ancillary objects, and then the second is by deciding other objects. Fashionable today for companies to put everything under the sun because they don't want to call a meeting afterwards and change the. You can change. I mean, you can always amend whatever you have written, but it requires a special resolution and it requires members to be present. Special resolution means about 75% of the members present and should vote in favor of the change. So nobody wants a headache. So naturally, what they do is they put everything, all the clauses are put in, and they make it a very chunky clause, objects clause. Then there is a capital clause, that is the incorporation. The company has been incorporated and permitted to raise so much of capital. You need to immediately raise the capital. You're just taking the permission from the ROC, or you're giving a notice to the ROC that this particular company in the future can raise 10 crores or 20 crores of rupees. You will have a liability clause. We always insist on that liability clause. The liability clause says that your liability is limited. And then the last, you have an association clause. The association is clause where I told you that there are at least 2 subscribers who will have to sign. That is where they will sign. They will say, I, so and so, son of so and so, residing at so and so, occupation being so and so, is desirous of forming the company, and therefore I have set my hand to this particular document on this day at this particular place. And then immediately there will be a witness who will say that, yes, I have witnessed the signing of this document. This is what you will contain in the memorandum of association. The articles of association consists of how the company will be run. Actually, others need not find out whether it is being done in that particular manner. They only need to know that there is an articles of association. So if I am dealing with a company, I will read the memorandum of association thoroughly and I will find out whether in their object clause, my permitted activity is allowed. If it is allowed, I'll go ahead, I'll enter into an agreement with them and we'll do business with the company. Now, how they are going to enter into an agreement, who will sign, all that will be found in the Articles of Association, because Articles of Association is like the rules and regulations. Now, I need not find out whether they have really followed it or not. That is not my business. I need not ask them, have you done it? I can take it for granted that they have followed it. If they have not followed it, they are responsible, not me. That is why Articles of Association is rules and regulations. Memorandum of Association is the incorporation law. So with this, I think I have nearly come to the end of my talk. If there are any questions, I will just try to answer these questions. What is the scope of, yeah, I think there is, what is the scope of pharmacy under franchise model during during COVID pandemic period? Well, I'm not expert in pharmacy. See, today, I just, if you read the newspaper, America has purchased or made a contract with Gilead. Gilead is a company which is American-based, American company, to buy all the stock of remdesivir for the next 3 months. So Gilead's remdesivir stock of July, 100% is purchased, 90% of August, and 80% of September. Everything will go to the United States. That means it is to treat 5 lakh patients, 500,000 patients, and for 500,000 patients, I think you require 6 doses. So you can imagine that they have purchased it. So what is going to happen to the rest of the world knows. But a pharmacy and a franchise model at this particular point in time could be a good proposition, but because things are now turned out to be very expensive. Somebody has asked me how to register a trademark. I think that is not valid out here. I'm talking about a company, not about a trademark. Maybe I can answer the question when we meet separately. Okay, fine. It's 11:29. Thank you very much, Yatish and team, for having me over. And it was a pleasure talking to you all. Wish you all the best, and stay at home and stay safe. That is all that I can tell you now. Okay. Thank you very much.
Thank you, sir. Thank you for this very useful session on forming a company for startups. I'm sure our participants had a lot to take out. And on behalf of everyone, I would like to extend our heartfelt gratitude to Professor Lionel for delivering such a beautiful session and answering the questions for the participants. Thank you, sir. Thank you so much. And I would like to thank all the participants for being with us this morning. Thank you, one and all. And I will send the feedback form link to everyone's email ID. So once you submit that feedback, you will get the e-certificate immediately. So with this, we have come to the end of this webinar. Thank you again. Thank you, one and all. Be safe. Thank you.